There.
Morning, Doug.
How are you?
All right. Good to see you.
Good to see you. I've got to get out of here right after your session to drive all the way back because I didn't fly down. I drove.
You didn't come down just for this.
No.
Okay.
I mean, I've been here since Wednesday,
Okay,
but yeah. I thought, gosh, when is Andrew giving his thing? And I looked at the schedule and I thought, well, I can make it from 9 to 10, and then I have to jet out because we have a dog being boarded that we need to pick up back in Chapel Hill by a certain time of day. So. Yeah, I'm gonna park myself back here. I hope you get some more people.
You're so kind to attend.
Oh yeah. All these grad students working with you. It's way out of my league, but
Enjoy it.
interesting.
Thanks. Which kennel do you use?
We actually out in Hillsborough, and so we have. Off of North A, after you cross 40 there. We've never boarded there. That all hung up on the way back. Yeah, the scheduling app that they use. Yeah, when they have multiple sessions. It just really varies.
It's 7.
Yeah.
It is 7.
Good.
If I saw the list, I'm sure I'd recognize the IP.
I met their dean. He's a little welcome. Thursday morning, but
Building's brand new, though, right?
Brand spanking new.
Is it really?
Yeah. Yeah.
Okay.
I don't know what they do that. Okay, I don't know. It's really.
I think should I? May as well get started. Well, good morning. Thanks to those of you who came, and especially to Doug Edmonds. I'm glad to see a colleague here. My name's Andrew Chin. I'm an associate professor at the University of North Carolina School of Law, and I'm a first-timer here at Cali. And I was talking to Doug earlier about the possibility of speaking here, and been interested in seeing what I've been working on. So this is a good chance to trade notes about using computers in instruction. I especially want to thank you for coming, given the complexity of the topics that I'm discussing this morning. So I'll be talking about the horizontal merger guidelines and the antitrust, and the computation of short swing trading liability under the Securities Exchange Act of 1934. Great topics for Saturday at 9 a.m. But you'll be rewarded, I think, by the prospect of seeing some possible real-world legal impacts, doctrinal changes that might be occasioned as a result of making things more amenable to computation. Larry Zelenak, who teaches tax at Duke, tells the story of the Rule of 78, this rule of thumb that taxpayers use to calculate part-year interest payments. And this is how they used to do it back in the 70s. And so this was intended to approximate the interest payments on an actual amortization schedule that was broken out month by month. And these are the actual numbers that you would get from that amortization. It's close, but a little bit off. But then HP introduced their, actually the calculator isn't showing up. HP introduced their financial calculator. And when they did that, that was considered publicly available technology that made it possible for individual taxpayers to do the job right. And so the IRS did away with the rule of thumb. The rule of 78 is no longer acceptable for calculating your part-year amortization payments. So here's a substantive legal reform that was brought about by the existence of a computational tool. That's sort of the payoff today, apart from the specifics of the laws that we're going to be looking at. What we do in developing technology for lawyers to use actually might lead to substantive legal reforms. So the two topics, again, that I'm talking about both come under Chapter 15 of the U.S. Code. We have the horizontal merger guidelines, which are used by the federal agencies, the Justice Department Antitrust Division and the Federal Trade Commission, Bureau of Competition, when they're reviewing mergers that are submitted to them under the Hart-Scott-Rodino Act. And these are just quantitative screens that have been in place. They've been revised from time to time, but they rely on measures of concentration in industries under concern, and they're used to support the case that the result of the merger will be likely to raise prices or reduce quality or quantity, cause the kinds of changes in markets that are of concern under the antitrust laws. So we'll be discussing two quantitative computations that the agencies do, calculating the Herfindahl index, and in some cases developing a theory based on the calculation of the Lerner index. Under securities regulation, under the 1934 Securities Exchange Act, we have a rule saying that you can't, as an insider, you can't make money off of short swing trading, and you're strictly liable to the corporation. You have to disgorge any income that you make that way, and that's under Section 16B of the Securities Exchange Act of 34. And this work is based on an article that also develops the larger themes about calculators occasioning substantive legal change, doctrinal change. Washington Law Review. This also has some related work to what we're doing at the conference. Hugh Gibbons, who's at University of New Hampshire some time ago, developed software for classroom teaching for his first-year tort students. He thought that it would be nice to have kind of an X-ray view of what his tort students were thinking when they wrote their answers to the big issue spotter exams. And have them think through the process kind of in groups of characterizing facts and applying law to them. So he developed this tool that he broke the class up into groups of 4 and had them develop basically choose your own adventure scripts, dialogues. And here's a software tool for doing it. He calls it Sheldrake Developer. And this gives, as they turn in the whole project, the whole path of questions and responses. And he gives an example of frames here with questions that could be asked. Why wasn't Betty's act a willed act? And there are 2 choices that the make, and the computer will next frame. There are 150 frames one group turned in, and this gives him a deeper view of how the students are thinking through the problem rather than just what they turn in under pressure during a 3-hour exam. And he published it. I don't know. I can give you the site to Hugh's piece. Okay, and then there's more closely related work to this to this work. I came across some literature in the economic education literature. So Scott Simpkins is an economics professor who, again, very early on was using the World Wide Web as an adjunct to his economics teaching. And he described 2 exercises where he finds the web useful. In one, he has the students break out into groups playing their roles as members of the Federal Open Market Committee. And so each of them represents a regional district. And they're supposed to go out on the web and find current economic conditions in their region, and then convene and decide what to do with interest rates. And then in the second exercise, he teaches the students about information and market behavior by having them compete to make money, I guess play money on the Iowa electronic markets. Roy Daniel, another economics professor, has created an extensive library of Java applets that represent economic models graphically under various parameters, including the Cobb-Douglas supply and demand models. Roger McCain has produced an online textbook with embedded JavaScript forms that allow students to plug in values and calculate functions, such as a production function consisting of two fields between which a farmer can allocate a fixed amount of labor. And so under the assumption of diminishing marginal utility and productivity, there's an optimal division of labor that the students can find via trial and error. And so McCain further describes this tinkering approach, and he contextualizes it as an application of the Karplus learning cycle. Bob Karplus was a famous physicist, and he devoted the last half of his career to science education. And he looked at Piaget and learning theories and found the cycle of exploration, concept introduction, concept application that now informs this approach, learning by tinkering. Okay, so to what I've been working on in antitrust. So the Herfindahl index is the summary measure, the statistic that the agencies use to characterize industries and how concentrated they are. And HHI can range from 0 to 10,000. 10,000 is a perfect monopoly, one firm, 100% share. You would get that by squaring. Actually, there should be exponent 2 here. Sorry. So 100%, 100 squared is 10,000. That gives you a measure of if you have an atomized industry, infinite number of firms with 0% share, squaring the infinitesimal shares is going to dominate that calculation, and you end up with 0. So that's the range. A duopoly with equal-sized firms is 5,000, and 4 equal-sized firms 2,500, and so on. So this can give you a measure of how concentrated the industry is. And the census keeps track of these measures for different industry categories, and these aren't the numbers that the agencies go on when they review mergers, but this is a construct that's well known in business. So these are the thresholds that are now current in the 2010 merger guidelines. And the agencies look both at the post-merger Herfindahl index and what the impact of the merger is, how much the index increases as a result of the merger. Give a green light if there isn't much of an increase, regardless of how concentrated it ends up being, or if there isn't that much concentration after the merger, have a large increase. And even in this category, presumed to be likely to enhance market power, the agencies don't always bring suit or try to stop the merger. Sometimes they'll try to fix it first with divestitures or other negotiated settlements, or sometimes they'll take a deeper economic analysis and decide that despite the structural effects of the merger and concentration, that there isn't a harm to consumers, and so they'll let the merger go forward. But this is kind of just an initial quantitative screen that the agencies do. And it's motivated, the use of HHI in this analysis, the Herfindahl index in this analysis, is based on some deeper economic theory, the Cournot equilibrium, which assumes that the firms are symmetric and they move simultaneously. But if sometimes merging firms make the argument that as a result of the merger, they'll become a much more efficient firm. And if they can make that case persuasively to the agencies, then this model doesn't apply so directly, and they can make the argument that they shouldn't be looking so closely at these numbers. So this was sort of the argument that Heinz and Beechnut made when in 2000 Heinz proposed to acquire Beechnut. And both companies, they're the number 2 and number 3 companies nationally in terms of share of the baby food market. Gerber is on the shelf in 90% of all U.S. supermarkets, and Beechnut and Heinz were sort of competing to be the second brand. And most supermarkets only have Gerber and one of the two, Heinz or Beechnut. So that was sort of their argument, was that, well, given the way supermarkets, they limit the number of brands that they put out on the shelf. So what we propose to do is merge. Then it'll be the same 2 brands on every store shelf, and we'll be big enough to compete head to head with Gerber. But the FTC went ahead and challenged this acquisition, and if you plug in these numbers into the Herfindahl index formula, you can sort of see why. Let's see if I back up here and plug in the numbers. This is the Herfindahl-Hirschman index calculator that's on my website, and you can do 60. Gerber 65, Heinz 4, Beechnut 4, others. And that gives you an HHI of 4769. And what this spreadsheet allows you to do is you can decide which ones are going to merge, click on those, and recalculate. And so from 4769, you go up to 5305. Right. So that was over 500 points of HHI gain, and that's in the red zone, right? You're highly concentrated market and way over 200 points of HHI increase. Okay, so just on the initial screen, the red flags went on in the agencies, and this argument about trying to buy their way into more supermarkets as unified second brand was not persuasive to the agencies. The agencies ended up successfully challenging this merger in the DC circuit. Any questions so far? Yeah.
Is it the FTC who?
The FTC and the antitrust division at the Justice Department. In this case, it was the FTC.
Okay.
Yeah. Okay. So I present this case or another case to my antitrust students. I also talk about the Staples case, and so the suggestion is that in having a more concentrated market, you're moving closer to a situation where the competitors there aren't enough competitors to step in and produce supply, offer supply to the market in the case of a monopolist who seeks to raise prices and reduce output. Okay, and so here's a cartoon that I have the students look at. You have a monopolist utility owner who decides to turn off the generator, and the invisible hand of the market allows him to make more money. So here's the very simple economic theory behind that. So again, this is provided as a graph for the students, but really what I want the students to do is tinker around with a market and see what happens when they produce it. So they're given this information. You're a firm that manufactures widgets at a cost of $2 per unit, and you face this downward sloping demand curve. How do you maximize your profit? A, under a situation of perfect competition, and B, under a situation of having a complete monopoly. So the students can tinker around with this, try making 100 of these things and charging $4 since it costs you $2 to make them. Under perfect competition, that's not going to be a winning strategy, because under perfect competition there are competitors willing to undercut you. Even if you charge $2.01 a widget, there's still profit to be made in undercutting you at $2.50. So this is a very idealized situation, but the point is that you'll be competed, the perfect competition will drive the market price all the way down to cost. And so the market demand at $2 is going to be fully met by that perfect competition. The market will produce 90. You're not going to sell any at your $4. And so you get zero revenue, and you're out $200 for the cost of producing those 200 widgets. So you can, if you don't get the sense yet that you should be charging $2, you can keep trying to cut your price. $2.01, still you're out $200. That does you no good. Okay, so let's just charge $2. What do you get? You still lose $20 because you made too many. You made 100, and there's only demand for 90. So let's just make 90, and then you get a profit of 0. And it turns out that's the best you can do. You can charge $1.99, then you're going to be losing money on every unit, right? So you lose 90 cents. Again, tinkering is going to lead you to the equilibrium here. And then you can do the same on the monopoly side. Let's try making 90 but charging 4. But at $4, you're only going to sell 60 because of that downward sloping demand curve. So let's just sell 60 then. And see how. And here you make $120. And so you're out here, and if you keep fiddling around, you find you can do a little bit better by charging, going $45 output, $4. Your profit goes down to 90 from 120. So let's charge a bit more. Let's charge $5. See how we do. Now you're up to 135, and that turns out to be the best you can do. So again, tinkering will get you to this equilibrium. Of course, this graph kind of gives away the game too. What the students find is that there's also this dead weight loss associated with that choice. Okay, and they can see that there's consumer surplus. These are consumers who would be willing to pay more than $5, and they feel a wealth increase to the extent of the difference between how much they're willing to pay and the $5 that they actually paid. And then the $135 profit, you add those together, that's not as good as if we were in perfect competition and the consumers were able to get all they wanted for $2. You might not make profit, but there's a total profit to the market of $270. And so society is $67.5 worse off as a result of this monopoly. And so this illustrates the concepts of allocational inefficiency as well as the distributive effects of monopoly. Questions about that demo? Okay, so for the remainder of my talk, again, it's based on this forthcoming article about short swing trading liability. And if you're interested, it's linked from the page for the session, and happy to talk about it with you later. But the Securities Act of 1934 provides that you're not allowed as an insider to make profits from any purchase or sale or any sale and purchase within 6 months of each other. And the issuer, the corporation that you're an insider of, is entitled to recoup any profits that you made in that way. There's a statute of limitations of 2 years. And it turns out if you've got a lengthy sequence of purchases and sales, this calculation can be pretty complicated. There are many possible ways of pairing up purchases and sales within that 6-month period. And so the lead case on how to calculate that short swing profit is 1943 case, Second Circuit's Smolowe versus Delendo. And it's a greedy algorithm. So it says, look at the lowest price per share and the highest price per share. And those transactions, the purchase at the lowest price and the sale at the highest price, might be for different numbers of shares, but you match up as many as you can, and then you pull those out of the calculation, you repeat the process until you can't do any more pairing. So that's been the lead algorithm since 1943, and this was Judge Charles Edward Clark, who had also been Dean of Yale Law School. So he had a lot of authority behind this formula. And this has been taught for generations. So this example is from Tom Hazen and Jerry Markham's securities law casebook. And here are 3 purchases and 3 sales spanning a 5-month period. So they're all within that 6-month short swing period. What should we pair up first? Yeah, buy low, sell high, right? So 100 at 35 and some of those shares at 50, 100 of the $50 shares. Okay, so we pull those out. We can then get a disgorgement of $15 times 100 shares, $1,500. So that's what we do. And there's 100 left over after we do that pairing, and we've got the 1,500. Okay, now what can we do? Yeah, we still have 100 at 50. We can pair them up now with 100 of the $40 shares. So we get another $1,000. Everyone see that? And now what can we do? Can't get any more profit, right? The lowest purchase is $40. The highest sale is 40. Well, you would get 0, right? Yeah. So you stop here. Now, so you get a disgorgement of $2,500. The corporation can go in and accuse this insider of making this profit, regardless of why he or she purchased and sold the shares on those dates. They can attribute this to their advantages of being an insider. Okay. Now, this has been heavily criticized, right? There are lots of other reasons why these transactions may have been taking place. But there are other commentators who say, the larger point is that if you're an insider, you shouldn't be actively trading in your corporation. You should be looking at the long-term picture, trying to increase your corporation's valuation over the long haul rather than engaging in speculation. So regardless of whether any inside information was used, this is considered a form of insider trading that the securities laws favor. And so, so this imputation of $2,500 sort of is belied by what's the actual profit through this series of transactions. So these 400 shares were purchased for a total of $16,000, and they were sold for a total of $16,000. So there's no net profit as a result of the sequence. But nevertheless, the insider is liable for $2,500. And so this rule has been considered harsh, but the theory is, and this again from the Smolowe case, that the point is to squeeze all possible profits out of stock transactions and essentially make a fiduciary out of the insider. And so this fiduciary liability theory has been supported in various ways. One is by looking at the statutory language. This is very broad language, and the statutory analysis highlights the appearances of the word any. Right? So this disgorgement is comprehensive. It covers any profit realized from any pairing of the purchase and sale, and so this this authorizes a plaintiff really to pick and choose, to cherry pick from among the transactions and find disgorgeable profit. And its economic interpretation has been that this is the maximum after the fact value that the inside information could have had, given the insider's stock transactions, regardless of whether inside information was actually used. As for the Smalowe lowest and highest out formula, though, that's a different story. Arnold Jacobs, in his 1987 treatise on Section 16, found a simple sort of counterexample, a hypothetical trading pattern in which the lowest and highest out rule that we just applied to that example failed to calculate the maximum possible profit. So the difference here is that we're not covering just 5 months, but here's an 8-month period. Okay, so does this work even when you're going over a lengthier series of transactions? Now, the Smolowe rule says we can still take profits out of that, right? There's a 6-month swing between the January and the May, right? So $2 per share, $1,000 there. And there's another swing between the August and September. Which one do we do first? Again, lowest and the highest out. $8 to $13, right? Okay, right. So, yeah, these sales, purchase and sale, were on the same day. That's as short as you can get, but that's the lowest and highest out is $5 a share. Okay. It was off the board, and then we compare the $9 with the $12 there. That's another $3,000. So we get $8,000 there, and then we're left with these two transactions which are now 8 months apart, and we can't pair those under the statute. Okay. So the Smalowe rule calculates the total recoverable profit of $8,000. Well, we can do better, right? Again, if we pair up in chronological order, we get 2,000 out of those two. 5,000 out of those two, and we still can pair up the two September trades at $2,000, and we get 9,000. So we can do actually better than Smolowe. And again, if we want strict fiduciary liability, we're going for the maximum. We're not just going for what would come out of this lowest in, highest out method. And Jacobs gives another example where the Smolowe rule can be beaten if the situation isn't that you're covering more than 6 months, but instead some of the transactions fall outside the 2-year statute of limitations. Okay, so so profit realized happens on the date of the second transaction. So you can actually have one transaction more than 2 years before the date of suit, and it can still be involved in the calculation, but only on the front end is the first transaction, not on the second. That adds a complication, and Jacobs says under those circumstances, you can also have failures of the Smolowe formula. So his conclusion is you can't use the Smolowe rule when trades cover a period of more than 6 months, or some trades are outside the statute of limitations. So between Smolowe and Jacobs' response to Smolowe, that still leaves a lot of open questions, which are the ones that are addressed in my forthcoming article. First, what is the worst case error of the Smolowe rule? Anyone want to guess? Yeah, and so in Jacobs' example, it was the difference between 8,000 and 9,000, so it's like 12.5%. Or actually 11.1% shortfall, right?
What does make any kind
Excuse me. Yeah.
if your compensation is
So you can't sell at a profit if you're an insider, which is a director, officer, or 10%. Purchase stock, you can't sell stock at a profit at less than 6 months. Well, it turns out that the amount by which the Smolowe rule may fall short of calculating the maximum profit depends on which of the two kinds of trading patterns are in play. So Jacobs' example that I showed you fell short of by 11%. You can have an error of up to 50%, and in the statute of limitations case, you can have worst case error of 100%. And to see this, it's a little hard with these colors to see this, but you can just exaggerate the numbers here. Here's an example covering 8 months, but everything's within statute of limitations. And if you pair lowest and highest out here, you would pair January with May. So from $1 to $1,002, and that would give you a million and 1,000. But you could do better by just going chronological order again, and you would get $2 million. And it's possible to prove that the Smolowe rule won't do any worse than 50%. So here's a constructive example of a 50% error, and then this is the proof that you can't do worse than a 50% error, which is in the paper. I like this proof, and it's kind of complex. I got to use graph theory in it, which I haven't done since in about 10 years. As for the other kind of problematic trading pattern that includes trades with beyond the statute of limitations, again, another exaggerated example. Here, the Smalowe formula picks up $1,000, but there's actually $1 million that's still on the table. Okay, well, these are fun, but are there actually cases, real cases, where plaintiffs and their attorneys have left money on the table? And so far I've found two, and these are discussed in the paper as well. One of them is a famous case, a learned hand decision, Gratz versus Clawton, which we'll discuss in a moment. The other is fairly recent. It's 2012, Ciccelli versus Vices Capital, which was a case brought by a shareholder on behalf of Bond Laboratories against one of its officers, Elorian Landers, who had made 333 transactions over a 15-month period. And the results of the Smolowe rule are summarized in this graph. The green down arrows are the purchases, and the red up arrows are the sales. And they're plotted horizontally by date and vertically by the price per share. What this one thing this graph doesn't show is how many shares were traded, but you can see a lot of the dots are paired up with more than one partner, because you might have those leftover shares that get paired up again. But a lot of these dots are left unpaired, and what you can see is you can do better by pairing them up in a different way. And if I flip back and forth, you can sort of see there are some pretty significant changes in those pairings. But on the other hand, ex ante, just looking at this, it's hard to see just looking at the pairing that you can do a little bit better by pairing them up in this different way. Another point this raises here, though, is that whether or not you agree with strict fiduciary liability, if you might think that this provision is just too harsh to define profits where profits might not really exist, allowing the plaintiff to sort of cherry pick like this. But it again is a widely recognized theory of Section 16b that prescribes this result. And the Smalowe rule it comes off as pretty arbitrary. If this is the result that's doctrinally prescribed, it's hard to explain what this is. Right? It doesn't correspond to any articulable theory of deterrence. It doesn't advance anybody's ideal approach to securities regulation, and it doesn't lend itself to coherent jurisprudence. It's a problem for everyone. So, even if you think sound public policy warrants raising the speed limit or faster traffic, raising the speed limit is the solution, not using faulty radar guns. So we'll come back to these doctrinal questions in a moment, but I want to move on to the third question left open by the Smolowe case, which is there a method that's always accurate? And the accurate method is actually based on a result that I published about 20 years ago in the Delaware Journal of Corporate Law, showing that the 16b calculation reduces to linear programming by way of the transportation problem. And you can just map those numbers into the transportation grid and solve the problem. Linear programming, in turn, can be solved by the simplex algorithm, which, unfortunately for Judge Clark in 1943, wasn't around yet. Or if you're concerned about computational efficiency, it can be solved by the Karmakar algorithm. But all of this information was freely available to the public when Ciccelli filed the complaint in 2012. Now, whether these algorithms were easy to use is another question, so I decided to do something about that, and Doug knows about this. With a small army of computer science students, I was able to get a 16b liability calculator online, and you're on 16blawunc.edu. I'm not sure you knew about. Did you know we'd put this up in the law school domain? Okay, so here's some example data, and you can calculate the insider's profits in both ways. Lowest in, highest out, the Smolowe method with this button, you get 6,800. This is an example that I had in the 1997 paper. I'll go back to the input tab and calculate with. So you can get 8,000 instead of 6,800 using linear programming. And there's some other nice things you can do. You can do an Edgar search. Anyone have a favorite corporate officer you want to look up? Tim Cook. So we get Tim Cook's CALIcon number. Oh. Cook Tim. Nope. Huh. Blank fine? Too many cooks. Trouble with this. I might not be able to. So, let me just make up a CALIcon number and see if we've lucky. Yeah, it may take a while. So what it'll do is it'll pull up all the Form 4 and 5 filings. This is where they report insider transactions to the SEC within the statute of limitations, and then it'll populate this form, and you can calculate theoretically what their liability would be. Now it's just a dumb parser, so and I'm not a securities law specialist, so I can't warrant that this will be an accurate calculation of liability. The forms just report what report transactions, a variety of transactions that many of which are exempt or characterized in ways other than fall under the 16B coverage. You know, there are lots of different ways of packaging options and shares as compensation to directors and officers that fall outside 16B. So again, this form provides ways of taking some of these transactions off the board before performing these calculations. And anyway, this calculation has to be heavily lawyered before you go and file suit.
What part of
Yeah, so I developed the algorithm for the calculations in mind, but they developed all of the interface below the narrative. Yeah. Yeah.
Would it
Well, actually, the plaintiff's bar will want to do this. The SEC actually doesn't have standing to file suit under 16B. sure there's likely to be a cottage industry in this once the plaintiff's bar finds out about this. So, this is kind of a nice tool then, right? But if we've been relying on this false empirical claim, again, that the Smolowe method has been inaccurate in some cases, including this example I put up. Is there any mathematical justification for continuing to use Smolowe? And actually there is if you don't run into those two situations that Jacobs talked about. So if all of the trades happen within 6 months and within the statute of limitations, the Smolowe rule can be used, and it'll give you the correct result. And so this is another proof that I provide in the paper. So this uses notion of a proof of correctness that uses an invariant that remains true throughout the calculation, and this is what the invariant looks like. And here's the final question, which makes a more general point again about the use of computational tools in legal practices. Why should we care about this? Well, so the problem is that there are two foundational Second Circuit cases, Smolowe and Gratz, which are still being misread. And in particular, Gratz is being misread as doctrinal support for the Smolowe formula. And the misreading has been a result of emphasizing this phrase, the only rule is lowest in, highest out formula. But the better interpretation emphasizes this rule, this phrase, within 6 months. And I argue in my paper that that limits the scope of the lowest in, highest out formula to the situations that Jacobs had not found problems with, right? All of the trades happening within 6 months. And that's borne out by the history of this rule. The rule actually came out of an SEC amicus brief that was filed in the Smolowe case, and it was never intended for application to longer trading periods than 6 months. And the Gratz case spanned 21 months, and this was the judgment in that case. This graph to the one you saw in Cicelli. And so under Smolowe, so this was the actual judgment. This was paper, pen and paper back then. They had these handwritten ledger books, and the judgment was based on this hand calculation, actually that the defendant submitted, and the defendant said, I'm only liable for $283,000. So they didn't even get the Smolowe calculation right, which would have been $50,000 more than that. And the Smolowe calculation falls short, it even falls short by a little bit if you compare it with linear programming. You can squeeze a couple $100 more out. And that might not seem like a big deal, but still it implies that that learned hand in the Gratz case could not have said, speaking out of the same mouth, that both there's strict fiduciary liability, that there must be maximum calculation of liability, and that the Smolowe rule is the right way to calculate it. Right? There would be a mathematical conflict between those two statements that wouldn't have been discovered back then, but it would have been a latent incongruity in opinion. As it turned out, a careful reading of the Gratz opinion shows that learned hand was very careful not to do that, and he didn't say anything in his opinion about the Smolowe formula. So this is why my article is titled the way it is. Learned hand formula, from tort law. Learned hand may have been fond of algebra and tort law, and very famously so, the learned hand formula. But in this Gratz case, he skipped the math. And so there are many reasons for not reading Gratz as authority for using the Smalowe formula where it's not valid to use the Smalowe formula, because next time the errors might not be so small. Nevertheless, in the intervening decades, we have many cases, many decisions, circuits that have relied on Gratz as authority for using the Smalowe formula when it's not valid to use the Smalowe formula. And big data methods are coming to 16b enforcement. It's just a matter of time. And 16b recoveries can be pretty sizable. So we've come to the point in the history of 16b where it's really no longer appropriate for the rule of law to rely on something like the rule of 78 that Larry Zelenak pointed to, just because it's easy to calculate if it's inaccurate. So even if I haven't inspired you to join the securities plaintiffs bar, I hope I've been able to provide you with a deeper application of the potential for computational tools to impact and inform the path of the law than written in the literature. Thank you.
Could you say a little bit more about the graph theory application?
Well, at least it seemed more intuitive to me to think of what's going on in the pairing of purchases and sales of shares as kind of a bipartite graph. So without loss of generality, you can consider just the whole shares case, right? And weight the graph by the edges of the graph by the number of dollars per share of recoverable profit that you could have. One share represented by each vertex and the recoverable profits on the edges, and looking for maximal coverings or matchings of purchases and sales. And you argue if you had a weighting that was maximal, you couldn't add any more edges through another pairing. It has to have at least half of the potential weight from a maximal matching. Okay.
Sure, I could give.
Okay.
Sure.
Questions, comments? Thank you for your interest.
Okay, help me. Do you explain this fully in your published paper?
Well,
the graph article proof?
fully in terms of providing the proof, yeah.
Nicholas, just a reminder.
Oh,
I don't know if you want to.
I will
Get
not
into
say any
fancy
dirty
votes.
words about graph proof. Let's see.
Oh, it's linked from the session page. So, but
It's somewhere
conference website. Let's see. Well, it's not elsewhere on the web, but it's the Learned Hand on formula for short swing liability. Okay.
I'll find it.
It's not going to be published till this fall, so if you give me a card, I can email you.
Oh, yeah. And
Sorry?
yeah,
Oh. Sure.
People on Slack were asking about your calculator.
People where?
People on the Slack channel were asking about
Oh.
your
which people?
the Slack thing, the company.
Are you able to see how many people
Where
went on
is
that
this?
on Slack?
Okay, what's your email?
Oh, chin@unc.edu.
CHIN@UNC. Is that your your last name without any alteration? That's pretty
I'm an old timer.
Yeah. Unformula.
Yeah, I'm sorry about that. When I log in, I think it appears, but
Andrew? Or
yes, Andrew. Yeah. So you know some graph theory then?
Well, I have a graph problem.
Oh,
Let me talk with you about it.
maybe we should do that. Okay.
Because maybe you can tell me the answer. Okay, so are you going someplace right now, or should we just sit over there and show you the problem?
Sure. Yeah, unless there's a session after this.
It's like a half hour.
Okay.
Just wanted to introduce myself. Francis Chin. Another Chin. On the Slack thing, like, if you wanted to, like, put comments on, is there like actual channel for that, or do you have to,
Well, we've got channels for each room,
right?
but I didn't really break them down further. So, you could either mention the title of the session. Yeah, I know, so are we a little bit, so, you know. I thought about doing stuff like having a channel for each session, but then, write stuff out, so. It's hard to tell what the sort of perfect mix is with this. It's a strange thing. Not Slack, Slack's awesome. It's the people that go to this kind of thing. Wait, what? Is this mic on? We love the people that go, no. I mean, it's an interesting thing, right? I mean, there's, well, you've been in there, so you know it's participation's relatively low. Half the people that are here know about.
There are a lot more people on doing Twitter.
Yeah, there are more people doing Twitter, which is also kind of new. I mean, it's taken now about 10 years now, I believe. But it's been a number of years, and you know, we're on Twitter. So Twitter's happening. This year I didn't. Last year I actually pulled the Twitter feed in. I didn't. That might have driven more to Slack too. So I don't know. I mean, we'll next year.
I don't know, you know, like it's some competition on Slack. And then there's like there's some fraternity having a conference in California.
Are they? Those boundaries catch up to the.
That explains a lot. Sarah was on
some conference, and I'm using some. All of a sudden, like these weird My Little Pony references started showing up under the hashtag. And at first she thought it was trolls, right? Just somebody like trying to message you. But then she poked into it a little bit, and she turned out that there was some get-together of, you know, brodies that guys were like, oh, it is. And they were using the same hashtag. And it was like, as like some legal.
Well, that'll be the next thing, a registry of
Hashtags.
hashtags.
Yeah, I'm kind of surprised that they haven't done that already. Yeah, it's sort of like making like the official hashtag. That is true.
Tell me when you're out here to watch it.
Yeah. Well, I think the room was.
I was gonna say, I took that in algebra, but I don't know that I can have flashbacks because I don't remember enough of it.
Not the drama? Of this, it takes a device to start a device. Yeah. So I have a little bit of a sound file. Yeah, is that gonna, that'll work. All right, cool. Looking for a place to plug a USB.
It's over here.
Oh, that would have been my fourth guess, thank you. I'm sure not. Steve, do you have a slide?